Hello, everybody. This is Samantha from the law offices of Samantha Wolfe. We're located at 20 East 6th Street in Suite 206 in Waynesboro, PA. And you can reach us at 717-655-2676. And today we're doing our monthly virtual seminar. We try to do every month a seminar from 12 to 1, at least once a month. Then what we do is we do upload our recorded videos to our YouTube channel. So if anybody ever wants to check out our previous seminars that we've done, you can head over to our YouTube channel, which you can access through our website. If you just type in the law offices of Samantha Wolfe, it'll take you to our channel. And we do have a playlist that's just all of our monthly virtual seminars. And I know that every month I get excited about the topic that we're going to be doing, but I'm so excited about today's that we're actually breaking up into 2 sessions. We're going to do a part 1 today, and then next month we're going to have a part 2. And then just so everyone knows, the months of June, July, and August, we are going to take off the time from doing monthly virtual seminars. And instead, what we're going to do is we're going to be premiering once a month conversations with my nieces. They're going to ask some questions, probably a little bit more basic, and we're going to put those on our YouTube channel as well for this summer. And then we'll be back in the month of September with our monthly virtual seminars as well. So if anybody ever has any topics they want us to cover, we're always happy to do that. All right, that being said, I'm going to go ahead and share my screen and minimize there. I'm learning all of these things as I go, so everybody's feedback is always helpful. So Jess is giving me the thumbs up. We're good to go. So this is a picture of the outside of our office complex. We're in the Landis Tool Building in Waynesboro. Like I said, we just recently switched suites. We're in the same building. We just moved from the first floor up to the second floor. So if you walk in the main entrance there under the maroon awning, you're going to get right on the elevator, come up to the second floor. We're right off the elevator. You can't miss us. You can reach us at 717-655-2676. And here's our mission statement. I always like to start off our seminars with this. Just a reminder that the reason that we want to do this and that we have our monthly virtual seminars is that we really want to make sure we're providing education for anyone who wants it, that we're getting out the newest information as we see in the news or whatever's coming in the legislation. So just know that we're keeping you guys in mind when we put together these presentations. So today we're going to talk about planting the seeds. When we got snow here yesterday, I don't know if anybody else on the seminar did as well, but we got snow yesterday and Monday. And so when I was thinking about how we were going to be doing one about planting the seeds, kind of spring, growth, all of that, it seems kind of ironic that we had the snow earlier in the week. So today we're going to talk about how to grow a successful retirement plan, part 1. We're going to go over 3 seeds. So I always like to give like 3 tips or tips through the presentation. So today I'm going to give you 3 tips, and then I'm really going to focus on the Secure Act. I'm going to explain why we're going to focus on that. And that's why there has to be a part 2, just because there's so much coming out about retirement plans. And so I want to make sure that we're keeping you updated. And even as I was putting together the presentation, there were some new bills that were proposed, and I'll go over a little bit of that at the end. And then our part 2 was really going to be covering those new bills that we saw kind of coming out of the House and the Senate. So with that being said, let's go ahead and get started. So again, I wanted to give 3 tips to start us off before we really started getting into the technical side of the Secure Act. So the seed number 1, or the tip number 1, is reviewing your beneficiary designations. So I'm always surprised at how often when I meet with clients, they don't understand that retirement assets are distributed separately from their will. So unless you have your estate designated as the beneficiary of your retirement plans, it's going to go to directly who you designated, and it's not going to go through the probate process. And the thing is, you don't want it to go through the probate process. Anytime you have the ability to designate beneficiaries, we always recommend that you do that. And we do that because if you pass away and you're in a nursing home, or you pass away and you have some outstanding debts that you have, those creditors, a nursing home as well as any other creditor, can recover against assets that pass through your will. So if you have an asset that has a beneficiary designation, we always recommend that you designate beneficiaries. We have a couple of people who do prefer or want to name their estate, and so that's okay as long as you understand the pros and the cons of doing that. And as long as you're informed, I feel like you're always going to make the best decision that you can. For beneficiary designations, it's essential to know who you have designated on your beneficiaries, and you should review them on a regular basis. So a tip that I've learned since we've been practicing law and dealing with this area, is that not only do you want to make sure you're reviewing your designations, but if you make a beneficiary change, so for example, if my dad is going to update his designations and he's filling out those change of beneficiary forms and he signs and dates it, I always tell my dad, you want to make a copy of what you submit to the company, because I've had a few situations where the beneficiary designations have been submitted, but they weren't properly updated on the computer system. And so the company will say, oh, these are the designations, or these are who the beneficiaries were, and it's not accurate. So please know that anytime you update your designations, we're always going to recommend that you make a copy of those designations and keep them as part of your record, because a designation is considered effective when you sign and date it. So if somebody's doing it and they're at their end of their life, we've had this a couple of times too, and they fill out the new claim forms, they sign and date it, and they submit it, and they pass away before the company either receives the updated designations or before they process it. And again, it's always the date in which you sign that contract, updating beneficiary designations. So not only do you want to review them, but you want to make sure that you have a paper trail of what you're submitting to the companies, so that just in case, if they don't have their records accurate and updated, that way you can make sure that your designations are correct and what you want them to be. The other reason you want to review them is life happens. So you may be designating children, and maybe, they get married and get divorced, or maybe somebody passes away, or there might be a situation in which a beneficiary has or develops a special need. And so you might be doing like a supplemental or special needs trust. And so you're updating the beneficiaries to be able to have it pay to a trust or to an able account for that beneficiary. So you always want to make sure you're reviewing those designations. That's why at our office, a lot of times we'll ask the client to fill out an intake form that just goes over their assets, so that we can make sure that we're not only counseling clients on the provisions in their will, but we can make sure their overall estate plan, so their will along with any beneficiary designations, make sure it's what they want and it's accomplishing what they want. So we recommend actually 3 levels of designations. So the primary beneficiary, the contingent beneficiary, and the tertiary beneficiary. The reason why we go to the trouble and the extent to name 3 levels of designations is that there's a lot of post-mortem planning that can happen with beneficiary designations. So for example, if we have husband and wife and maybe they're doing asset protection or nursing home protection and they have an irrevocable trust, they might designate the trust as the primary, they might name the spouse as a contingent beneficiary, and then they may name their children as the tertiary beneficiaries. It's helpful for 2 reasons. The first is it offers tax planning. So if when one spouse dies, if the surviving spouse disclaims it and gets it so that it's down to the children, especially with life insurance death benefit proceeds, there's some tax benefits to doing that. So it gives you the option to say, we don't know who's going to pass away and in what order and what the health status or the tax laws are going to be. So let's name primary, contingent, and tertiary beneficiaries. So that would be one reason you want to do it, for some tax planning after death. The other reason you might want to do it is for nursing home planning. So retirement in Pennsylvania is only available for your own care if it's your own retirement, but your spouse's retirement is not available for your care. But if my dad goes into a nursing home and my mom has my dad listed as the primary beneficiary on any of her retirement accounts and she passes away, dad's in a nursing home, all of that retirement is going to the nursing home or going to be an available resource for the nursing home. So sometimes we'll name the trust as the primary, because then we can say, okay, if dad's in a nursing home, it goes to the trust and is protected. If dad's not in the nursing home, he can disclaim it as the trustee of the trust and it can pay to him outright. And then technically he could disclaim it on 2 levels. He can disclaim it as the trustee, he can disclaim it as an individual, and then that would allow it to go to the children, my sisters and I. So it allows for multiple planning opportunities. And again, this is all planning that would take place after death. And by having the designations, multiple layers there, it's really helpful. So you should not name your estate as the beneficiary or as a contingent beneficiary for your retirement plans. And we've talked about why, because of the creditors. That being said, I did have one instance where we actually did recommend it, and it was because it was a whole bunch of charities that were going to be the designees on the retirement account. And rather than name them in the small percentages, the individual just decided to name their estate so that way, if they updated their will, those designations would automatically be updated because it was paid to the estate. So that's the only occasion in which we've done that. Number two, so again, we're talking about the 3 C's for retirement planning. The first one was making sure that you have those designations on the retirement accounts. The second thing is to have a good legal foundation with your documents. So I know anybody who's on here that's been on our virtual seminars on a regular basis knows that we always talk about the power of attorneys and how important they are. And that's because it allows the planning not when you pass away, but during your life if you need to do some additional planning. So for example, when we're talking about a nursing home or any type of situation. I have a husband and wife who are in their 90s, and wife has pretty severe Alzheimer's at this point. And so we wanted to name a supplemental needs trust for the wife as the beneficiary, and the husband was actually in another facility, and it was during the lockdown period of COVID, and so they couldn't get out to sign the designations or to submit the designation forms. So they wanted son, who was named as the agent under the power of attorney, to be able to update those designations. The issue was that the power of attorney document did not actually permit the agent. The agent is who you're appointing to have those powers. The power of attorney didn't allow the updating of beneficiary designations. So not only do you want to make sure you have a power of attorney, which is that written legal document where you're appointing somebody to handle your affairs if you can't, you also want to make sure that if you have one, that that document has all the powers that you want your agent to have. So there are usually 4 powers in Pennsylvania that we call our hot powers. And those 4 powers, it just means that you have to have the specific language. If you don't have the specific language, then your agent doesn't have that ability. And so one of those is updating beneficiary designations, which is really important for retirement planning. So you want to make sure you have a good financial power of attorney. So in Pennsylvania, they no longer assume that you like your spouse. So it used to be that your spouse, it was assumed was your agent, but now Pennsylvania doesn't assume that. So your spouse doesn't automatically have the right to be able to do these things. You have to grant them that under the power of attorney. And if you don't have a power of attorney and you lose capacity, then your spouse or your loved ones would have to pursue a guardianship. And a guardianship is just the process by which you're petitioning the court or a judge to be able to say, okay, this person didn't have a power of attorney, but I would be who they would want to be appointed. And so a guardianship is usually more expensive. So a power of attorney, can be a couple $100, where a guardianship can usually rack up those attorney's fees. Sometimes you can get between $3,000 and $5,000 worth of attorney fees. So having a power of attorney is so important to make sure that your agent can act in your best interest. And the other reason why you don't want to have to go through the guardianship route is that it sometimes can take 3 months or more to obtain a guardianship. And so if you're dealing with nursing homes, if the average cost in Pennsylvania of a nursing home for 1 month in 2022, that increased to $14,676. If it takes 3 months, then that's $44,000 that your agent isn't able to protect or do planning for. So you want to make sure that you have a power of attorney and that your power of attorney has all of the authority and all of the powers that you want your agent to have. So C number 3, so we talked number 1 about making sure to have designations on your retirement plan. Number 2 is making sure you have a good financial power of attorney and those good legal documents in place. And then number 3, we talked about a little bit, but it's layering those designations, and that's protecting the retirement assets from the cost of your long-term care. So if you think of it like a cake, you have to have those layers, the different options as far as what you want to have happen. This year, from 21 to 22, we've seen the largest increase in long-term care costs than we've ever seen since I've been practicing law. So just so everyone kind of has a frame of reference as to how big the increase was, in 2021, the average cost of nursing home a month in Pennsylvania was $11,099. In 2020, it was about $10,700, around there. So it jumped a little bit, about $300 there, in $300 a month from 2020 to 2021. But when it jumped in 2021 to 2022, we saw the largest increase. So instead of it being $11,099, it jumped up to $14,676 on average a month for skilled level care in a nursing home. Now, the average cost of assisted living is usually between $3,000 and $4,000. That depends on where you're located. So it tends to be the closer to the big cities, the higher the cost of care is. But we wanted everyone to know that these costs are increasing. So when you're talking about protecting assets when you're talking about retirement planning, it's important to know that retirement is one asset that is going to be available for your care. And in some of our other seminars, we talked about how we can use trust to protect assets. A lot of people opt not to transfer retirement accounts into the irrevocable trust that we can use to protect assets. The reason is because it triggers all the deferred income tax that you've had. It triggers it all at once. So a lot of people don't transfer their retirement accounts into the trust. And the problem with that is if the cost of care is increasing, then that means that a lot of retirement accounts are in jeopardy for being used to pay for the cost of care. But when we're talking about layering the designations, it just provides a lot of flexibility for tax reasons as well as for long-term care costs. We want to make sure we're layering them. So we have an example. So if your spouse is in a nursing home, you might want it to be the trust as the primary, the spouse as the contingent, and then the children as the tertiary beneficiary. Now, know if the spouse is in a nursing home, this trust will protect the retirement money from the cost of care. So if we take my mom and dad as an example, when dad needs nursing home costs or needs nursing home care, I should say, his retirement is available for his care, but my mom's retirement is not available for his care. That's Pennsylvania, a Pennsylvania specific rule. That being said, if when my mom dies, if my dad is designated as the beneficiary, then we took something that wasn't originally available for his care because it was my mom's retirement. And when she passes away, it's all going to dad and it's all becoming available at once. So by layering the designations, what we're doing is we're allowing the option for it to be protected. But again, if my dad is not in a nursing home, he can disclaim because he would be the trustee of the trust that would be the primary beneficiary. He can disclaim it and it would pay to him outright as the contingent beneficiary. And then if we wanted to do tax planning like we talked about, my dad could actually disclaim it a second time so that it went to children or whoever mom and dad had as their tertiary beneficiaries. So layering that designation is actually a nice way to do planning without actually having to have a legal document. So we include it in all of our discussions, but it's not actually a legal thing that we have to do. It's just making sure those designations give you the maximum amount of options that you can have. One thing I will say is it's better now, but it used to be companies did not accept tertiary beneficiaries, or in some cases, they're called second contingent beneficiaries. And so what we would have to do is our office would actually prepare the designation form. So the company would give us a change of beneficiary form and we would just put like C attached. And then we would type up the primary, the contingent, and the tertiary beneficiary and submit that with the change form that the client had signed and notarized or whatever the requirements were for that change. Now we're seeing more change of beneficiary forms that allow for either a second contingent or a tertiary beneficiary. So we're not having to do that attachment as much. But know that some companies still only have a primary and a contingent beneficiary. And just because that's all they're saying they accept doesn't mean that you can't name a third beneficiary. What it means is that they're just going to keep your attachment as part of the record so that when they're paying it out, they know, even though it wasn't on their change of beneficiary form, that this was something that you requested. So again, it's just navigating and talking to those different companies and figuring out what is their requirement internally. You can name your children outright as the tertiary beneficiary. You can also name a revocable trust if you don't want all the retirement to go out to your children or you don't want them to be able to cash it out all at once. So retirement is something where a lot of times when someone passes away, and we're going to get into what the Secure Act did as far as the distributions out to the beneficiaries, but a lot of times the beneficiaries have the option to either take it over a period of years or to cash it all in the first year, take all of those funds. The problem with the cashing out is that it could push them into a higher income tax bracket. So a lot of times when I'm talking to mom and dad, they'll say, well, no, I don't want them to take it all at once. And so if you're in a situation where you have quite a bit in retirement, you might want to consider designating trusts for children or for grandchildren so that they don't have the option to cash it all in. And we're going to talk a little bit about how that works when you name a trust as the beneficiary designation or designated beneficiary on your retirement accounts. So a revocable trust, if you have sub-trusts that are created for your kids at your death or at the death of the second spouse, that would protect those funds against the 4 Ds. And the 4 Ds are divorce, debt, disability, and death. So that just means that if mom and dad wanted to name my sisters and I as the beneficiary, and they named trusts that were created for us, and one of us got divorced, the divorcing spouse cannot touch those retirement assets. Second thing is if we had any debt, meaning car accident, somebody was suing us, they can't touch anything that's paying to the trust. Third D is the disability. So if one of us would ever have a special need or some sort of disability in which we could qualify for government benefits, having it pay in trust would protect those retirement funds, and they would not have to be spent down in order for us to qualify for that government benefit. And then the last thing is death, meaning that if one of us would pass away, it doesn't go through our estate, it would actually go to directly who my parents have designated in that trust document. So layering the designations using a trust for the kids can be really helpful. We have the picture of Darth Vader there, just saying that you never know how that can impact your life. It could be that, you like your in-laws, whoever your children marry, but it could also mean that you don't know what that person is capable of. So for example, I'm not married. So if mom and dad said, we don't know who she's going to end up with, so maybe we want it to go in trust for her. So just preparing and protecting those assets against that potential Darth Vader, that potential creditor, is always helpful. Okay, so I breezed through those 3 seeds because what I wanted to do is I wanted to spend a good amount of time talking about the Secure Act. So I know that a lot of you are really well educated, follow the news, and kind of know what's happening with retirement plans. But for those of you who don't know, or if you need a refresher, the Secure Act is legislation that President Trump signed into law. He actually signed it in December of 2019, and it became effective for anyone that passed away after January 1st, 2020, or if you hadn't reached 70 and a half by January 1st, 2020, this new law affects you. So let's talk about what did the Secure Act do? And know that for those of you who have been following the news, we have a Secure Act, what they're calling Secure Act 2.0, that's making its way through Congress now. And that's what a lot of our, the retirement planning part 2 is going to go over, is what are we seeing? Because it's looking like they're already proposing new changes. And it seems likely that those changes will happen because the 2 lawmakers who are proposing and sponsoring this bill are the same 2 individuals that proposed Secure. And it happened really quickly, and it got bipartisan support. So it's likely that the Secure Act 2.0 will pass this year. So I want to make sure that we're talking about that. So know that our part 2 session will talk all about that fun stuff, and I'm looking forward to it. So hopefully you guys can be on there next month when we have that. So what stayed the same with the Secure Act? So the first thing to know is that some of the definitions stayed the same. So we had this definition of what a designated beneficiary is. So we know what is not a designated beneficiary. So initially, an estate, if you named your estate, if you named a charity, and if you named a trust, those are the 3 things that weren't considered a designated beneficiary because it wasn't a natural person. So what they did is, through private letter rulings, the IRS did allow for what they called a see-through trust. And I'm using that in quotations because that is just a trust in which they're saying normally it wouldn't count as a designated beneficiary, but we're going to look through the trust and see who those beneficiaries are. And if those beneficiaries are individuals that would have been considered a designated beneficiary outside of the trust if you had designated them, then if those are the only beneficiaries of the trust, we're going to allow that to be considered a designated beneficiary. So that being said, if you had a trust that had a charity or had the estate listed as a beneficiary of that trust, then that was not considered a designated beneficiary. However, if my parents had created a trust and it was my sisters and I and their grandchildren who were the beneficiaries of that trust, that counts as a see-through trust, and it meets the qualifications of a designated beneficiary. So the definition of see-through trust has not changed. Accumulation trusts are effective for asset protection, but may have accelerated tax. So accumulation trusts, there were 2 types of trusts that were used in retirement planning. There was a conduit trust and there was an accumulation trust. So the difference between these 2 categories, so first of all, know that we finally, in the Secure Act, got defined terms for what a conduit and accumulation trust were. And an accumulation trust just means that when it's pulled from the retirement account into the trust, that it stays in the trust so that it's protected against the beneficiary's creditors. A conduit trust pulled it from the retirement account and then immediately paid it out to the beneficiaries. So there was no creditor protection that way. So know that accumulation trusts, even after secure pass, they're effective for asset protection. However, you may see some accelerated tax. And so we're going to talk about that in some later slides here. The other things that stayed the same was that if a participant died on or after the required beginning date, that means it used to be 70 and a half, now it's 72. But if they had died on or after that, a non-designated beneficiary has to withdraw the remaining benefits over what would have been left of the participant's life expectancy if the participant had not died. And if the participant died prior to starting the required minimum distributions, then the 5-year rule applied. So all of that stays the same in secure, okay? Couple of other things that stayed the same is a trust with non-designated beneficiaries. So again, creditors, charities, or any non-persons as beneficiaries, they may be required to use the 5-year rule if the plan participant had not yet started taking their RMDs. If the plan participant died before reaching the required beginning date, which is generally April 1st of the calendar year following the age of 72, then the spouse who inherited the IRA would not be required to pull anything out of the IRA until the year in which the deceased plan participant would have reached the age of 72. So all of that stayed the same. Those were the rules prior to secure, they're the rules after secure. So let's talk about who is not affected by secure before we talk about the changes. So know that if we have a client with no retirement, no funds in either an IRA, 401k, anything that's considered qualified, secure doesn't affect them. And secondly, a client who has all retirement, and we have to emphasize the word all the retirement pays to charity, secure really doesn't impact them either. So those are the two situations in which if we have a client that has no retirement or we have a client where everything's going to charity in retirement, then we don't have to worry about what secure does for them, okay? So let's talk about what secure really impacted. So what it does is for most beneficiaries, and we're going to talk about the different classifications, for most beneficiaries, what we're losing is the stretch. And so the stretch was just saying that if mom and dad had passed away, and if I'm receiving their retirement, I can choose to take, this was pre-secure, I could choose to take it over my life expectancy, meaning there'd be a required amount that I have to take out of the retirement every year, but I didn't have to do it all at once. And I could pull it out gradually over my life expectancy, which meant that in theory, I shouldn't have to pay as much tax because I'm pulling it down slowly and it's not pushing me into a higher bracket. So what this means post-secure is that we're having to do a lot of planning without having the stretch. So is the stretch, meaning stretching out over your life expectancy, is that really necessary? So if a client has a small retirement plan, less than 50,000, then you're not going to see a big impact in this. Because again, when you're looking at the numbers, it's just that's kind of the point at which you're going to be like, yes, it stinks that I have to pull it all out. But in the grand scheme of things, I'm going to have pulled it out over because it's now a 10-year period. So again, you're not going to see a huge impact there. The second thing you have to ask when you're talking about planning without the stretch is who is the beneficiary of the retirement? So when we're thinking about stretch or no stretch, a lot of times people were like, well, can the beneficiary handle the money? Meaning that, do we have creditor issues? Are they financially responsible? Is there a situation in which an outright distribution to the beneficiary is problematic? So that's where we're talking about the divorce, disability, those situations. And then how bad does the client care about the benefits of trust planning or asset protection? So when I'm meeting with a client and we're talking about planning without having this stretch, these are the questions that I ask. How much is in retirement? Because if it's less than 50,000, you're not going to see a huge impact. Who do we want the beneficiary to be of the retirement? And how well do they handle the money? And so these are all questions that we're asking. And the reason why this is important is because here are the key changes in secure. So the first is that the first distribution is now age 72 rather than 70 and a half. So that's if you had not reached age 70 and a half by the end of 2019, then your required minimum distribution age is 72. Additionally, there's no age cap on contributions to traditional IRAs. So pre-secure, it was the calendar year you turned 70 and a half. Post-secure, there's no age cap on contributions to an IRA. Third thing that changed is annuities are now permitted inside 401ks. So prior to Secure, we couldn't do that. Now we can. Another key change was post-mortem RMDs over the life expectancy. The stretch of the beneficiary is eliminated and all money must be out by the 10th year. So that was the big change. If I could put this in neon letters flashing, that would be the big change that you're going to see. So it benefited, the Secure Act benefited all plan participants, meaning that if it's your retirement account, the benefit you have is that you can delay taking the RMDs until 72. But by making this change from taking away the stretch to a 10-year payout, know that they estimate, the IRS estimates that they're going to get an additional $15.9 billion in revenue that they're going to receive from this change. And that's what they calculate just in the first 10 years. So this change has a huge impact on the beneficiaries and the taxation. So let's talk a little bit about that. So I have some charts up here just so you can kind of see what we're looking at. So this was how the stretch worked. So if we have somebody and from 2019 to 2029, you can kind of see what age they were, the balance of the IRA at the end of the year, the life expectancy factor that you had to use, the RMD, and then this is calculating the 7% growth. So you're going to see kind of what was paid out, what the RMDs were, what the balance was in a 10-year period. So you have a balance of 1.5 million. If you're looking at a math 10-year rule, then same categories, but you're going to see that the balance is 1.2 million, as opposed to if you were able to stretch it, you would have 300,000 more, 1.5. So you're going to see a big impact. So if they're able to do this for every retirement account, that's where they're generating that revenue, because again, the difference is the balance of 1.2 versus the 1.5. So this affects the individual income taxes of the participant. So what does this mean? So the tax rates, we call this the tax creep. The thresholds change every year. You know, the brackets, I should say, you're going to see the amounts change. So it not only affects the beneficiary, but it also is going to affect the plan participant. So again, you see a lot of benefits for the participant, not as many benefits for the beneficiary. So the Secure Act was passed the end of 2019, just to kind of give you a timeline. So it applied after December 31st of 2019, but we didn't have any regulations. So know that regulations really explain what the tax law did. So they kind of really give background and explain what the legislation was intended to do and how we're going to see it play out. Let me give you an example. So when Secure Act was passed, as attorneys do, everybody started talking about what does this mean logistically. So in January 2020, everybody was trying to figure out if all of the retirement funds have to be out at the end of year 10, which really technically is 11 years, does that mean a beneficiary could wait until year 10 and just pull it out all at once? And this was going to have a huge impact in two situations. One, where a beneficiary might retire within those 10 years. So they might drastically change the tax bracket they were in. That's one situation. The second one is if we had a client who part of their estate plan was it stayed in trust, and at certain ages, certain payouts happen to the beneficiary. So a popular way to set up a trust is that at 25, they receive a third. At 30, they receive half of the trust proceeds. And then at 35, they receive it all. That's a common interval payout for a lot of trusts. So if the beneficiary was, let's say, 30 at the time that the person passed away, then could you delay taking those funds out of the retirement until after they turn 35? Because think about it, a trust has the same tax brackets as you and I, but the thresholds, the actual amounts until you get pushed into the high one are very different. So if you have income over about 13,000 and it's in a trust, you're going to be at the 37% bracket. Plus, most likely you're going to be hit with the additional 3.8% Medicare surtax. So you would have a very high, you would be, 40% tax rate, where if you were an individual and you were receiving that, you may only be in the 32% bracket. So it makes a difference. So in that case, if the rule was going to be that it just all had to be out in year 10, then you would just advise your beneficiary to wait to take those distributions out of the retirement for tax purposes until after age 35, because the trust wouldn't be in play then and we would be under their individual tax bracket. So that was one way in which, as attorneys, we were trying to figure out planning. So we needed these regulations. So the proposed regulations were supposed to be issued in September of 2021. We didn't see them. And we didn't hear anything about when they were supposed to be coming. So everyone had said it's going to be September 2021. It's going to be September. September came and went. October came and went. Nothing. And we didn't hear any updates. And then lo and behold, in February of 2022, as a surprise for all of us, we got the proposed regulations issued. What was interesting to me about the proposed regulations is that example I just told you about waiting until year 10 and pulling it all out. Most, and by most, I mean probably 80% of legal professionals, legal practitioners were saying that in those 10 years, you didn't have to take a required minimum distribution as a beneficiary. You just had to take it all out in year 10. And that's what we were all operating under, that assumption. In the proposed regulations, where they're explaining what the intent was and what they're going to do, one of the things in the proposed regulations was that no, you still are going to have to take as a beneficiary RMD, a required minimum distribution. It's just that when you get to year 10, you have to take it all out. So years 1, 2, 3, all the way up to year 10, you're going to have an amount you have to take out every year and pay tax on. And then in that 10th year, you have to take that plus anything else in the retirement account. And that was something that about 80% of the legal professionals didn't anticipate, because again, we were just reading exactly what the law or the legislation that had come out. So these proposed regulations have really had an impact and kind of changed the way that we saw this practically apply to our clients. So they were issued February 23rd, 2022. Comments, that means like professionals, legal professionals, they can comment until May 25th. A public hearing is scheduled June 15th, 2022. And then after that, they're kind of finalized then. So it's very interesting, the kind of the process of what we saw. So in the proposed regulations, we saw definitions of things that we'd never seen before. And by that, I just mean that attorneys had kind of come up with their own definition of what, like an accumulation trust, what a conduit trust, what did that mean? Because we didn't have definitions before. So we now have definitions for an accumulation trust, a conduit trust, see-through trust, all of that. We know that RMDs are going to be required if the participant was receiving RMDs when they died, and that would mean they're 72 or older. Now, no RMDs are required if the participant died prior to taking RMDs. So that's interesting to me. So if you have somebody who passed away at age 70 and wasn't taking the RMDs, then that beneficiary can wait until year 10 and pull it all out. There's not going to be an annual amount that comes out. But if the plan participant was 73 and receiving RMDs, that beneficiary is going to have a required amount annually that they have to withdraw, and then in year 10 they have to pull it all out. So that was interesting in what the proposed regulations had. I don't know that a lot of us attorneys thought that was the way it was going to play out. And that's simply because when we talk about if there's a non-designated beneficiary and it has to be pulled out within 5 years, there's no annual required amount. It's just all out in year 5. So when we were talking, kind of analyzing how we thought this would work, we were basing it on what Congress had done with the 5-year rule. And so just like anything else, you never know what they're going to pull out of their hat as far as the rules. So know that this was different than what we thought. And so for beneficiaries, this might change and they do still have to take RMDs. So I know that that was a very long-winded explanation of why these proposed regulations are a big deal, but they are a big deal. So, and I like talking about them. So yay for everybody, right? So now I have the new default rule, the 10-year rule. So what does this mean? So there are a classification of beneficiaries that are like the superheroes of it. That's what I'm calling these. So no, we have designated beneficiaries. That would mean individuals, non-charities, can't be your estate, no creditors. That would be considered a designated beneficiary or a see-through trust. But we also have this superhero classification. and they're what we call the eligible designated beneficiaries. That means that they're so important. These people are so special that they're going to get the stretch. So some of these we knew. Surviving spouse, for example, if you have named your surviving spouse as a primary beneficiary, they can stretch that over their life expectancy. That makes sense. That's what we've seen historically. So they're considered what we call an EDB, or an eligible designated beneficiary. Another class of eligible designated beneficiary is a minor child. So that means that as long as they're a minor child, then they can take the required minimum distributions over their life expectancy rather than the 10-year rule. So interestingly, a lot of our clients, we saw a lot of teachers and physicians, they may have designated minor grandchildren because they wanted it to go in trust, and tax-wise, it made a lot of sense because a grandchild is going to have a longer life expectancy than a child. So we saw, as part of mitigating taxes and doing some tax planning, we saw a lot of grandparents skip their children for retirement designations and go to their grandchildren, whether it be outright or trust, just because they can pull it out over a longer period. Well, know that it's a minor child, meaning that if you have grandchildren thinking that they're going to get the life expectancy over their age or based on their age, that's no longer going to apply. They're going to have to take it in a 10-year period as grandchildren. So the only time this applies is if it's a minor child. The thing that the proposed regulations did is that we weren't sure what was considered the age of majority, because if you have somebody who is age 16, then they're going to get the stretch out for a few years, but then at age 18, do they flip to a 10-year rule, or is it age 21? What's considered the age of majority? Every state has a different age. So was it going to be state specific? How is that going to work? So what we saw under the proposed regulations is what they defined as the age of majority is 21. So what that means is if you have a minor child designated as your beneficiary, once they reach age 21, they immediately flip to a 10-year rule. So what about a stepchild? Again, it says child and it's defined, the age of majority is age 21. So we're going to see how this all plays out for stepchildren, and do they apply, do they not apply? The other classification of eligible designated beneficiaries would be a disabled individual. And the Secure Act did define what they considered a disabled individual, and it's different than how Social Security defines them. So this is really frustrating for me as an attorney, because I may have somebody who's getting SSI or SSDI, and they may be qualified for that benefit, or their parents may have done a special or supplemental needs trust for them, where their inheritance goes in trust and it protects it so that they can still receive whatever government benefit, SSI or SSDI, that they're on. Well, this is frustrating because I have to use one definition in order to get them qualified for SSI or SSDI, but then Secure is going to have its own definition of what's considered a disabled individual. And if they're considered disabled under Secure, they get a stretch. So I talked with a client probably about 2 weeks ago, and they have one child who has special needs. And so we talked about, well, maybe we want the child with special needs to receive a higher percentage of the retirement account, and the non-disabled child to receive more of things under the will. Because again, the disabled individual can stretch it over their life expectancy, so it's better tax-wise. So it's thinking through. You need to make sure that you and the attorney are thinking through all of the options there. But just know that just simply because your child qualifies or grandchild qualifies for SSI or SSDI doesn't necessarily mean they're going to be considered disabled under Secure. So that's a little frustrating. The next category is a chronically ill individual. So this individual would also be considered an eligible designated beneficiary, meaning that they get the stretch out over their life expectancy. And so we see this a lot with, if it's maybe a sibling that you've named and maybe they're receiving long-term care, maybe they're in a nursing home, they're going to get the stretch out over their life expectancy. And then lastly, of our eligible designated beneficiaries of that superhero class, we have individuals not more than 10 years younger than the participant. So again, met with someone this past week, it's actually a sibling. They are 8 years younger than their deceased sibling. And so they're going to meet this eligible designated beneficiary classification. So they're going to be able to take it over their life expectancy as opposed to the 10 years. So those are our superheroes. Those are the beneficiaries who still get the stretch. Everyone else is going to have the 10-year rule. We now have designated beneficiaries and eligible designated beneficiaries. So we have this new defined superhero term. So that's what the Secure Act changed. The RMDs, though, are still considered income. So know that anytime somebody's pulling money out of a retirement account, it's still going to be considered taxable income, and they have to include that in their adjusted gross income. There are still penalties for not taking the RMDs in the Secure Act. And you still have to determine the identity of the beneficiary. So know there are a couple of dates that you have to keep in mind when you're administering an estate, and determining the beneficiaries is September 30th in the year after death. So if you do have a charity listed, for example, you can pay them out prior to the September 30th deadline, and then all the other beneficiaries count as designated beneficiaries, which either means they get the 10-year rule, or if they are those eligible designated beneficiaries, they get the stretch out. Okay. Phew. I think now we get to talk about designated beneficiaries. I know you guys are enjoying this. I feel like this is more definitions than I normally have to talk about. So just bear with me as we go through the designated beneficiary. So an individual named as a beneficiary by the participant or by the plan. A see-through trust can also be considered a designated beneficiary. Those eligible designated beneficiaries, so that's the spouse, the minor child, the disabled individual, the chronically ill individual, or the individual who's less than 10 years younger. They're all considered designated beneficiaries. And RMDs was also defined in the Secure Act. So how does the 5-year rule still come into play? Because this rule is still in effect. So if the plan participant died on or after their required minimum distributions, their date in which they have to start taking those, a non-designated beneficiary has to withdraw the remaining benefits over what would have been left of the participant's life expectancy if the participant had not died. If the participant died prior to starting to receive RMDs and there was no designated beneficiary, then the 5-year rule applies. Now, interestingly, the 5-year rule is applied differently than the 10-year rule. Like I talked about, the 5-year rule, you can wait all the way till you're 5 and then take it out, where we now know that the 10-year rule still means you have to take a required amount every year. A trust with non-designated beneficiaries, so that's where creditors, charities, or anyone who's not an individual, so like an estate, if those are the beneficiaries of the trust, they may be required to use the 5-year rule if the plan participant had not yet started taking the RMDs, or they may have to take the RMDs over the life expectancy of the deceased plan participant if they had started taking RMDs. So the 5-year rule, if the owner had died before age 72, or the owner's life expectancy, applies if the beneficiary is not a designated beneficiary. So that's what I'm saying. There are so many definitions, and it depends on where you are. If you've started receiving your RMDs or not, then that's going to determine what your beneficiaries have to receive the payments over. Eligible designated beneficiaries still have to take the required minimum distribution in the year of the owner's death. And then they do avoid the 10-year rule and can use their own life expectancy. It does, or it can reset to the 10-year rule if, again, it's a minor child and they reach the age of majority, which is 21 under the proposed regs, or if this disabled individual recovers and is no longer considered disabled, then it flips to the 10-year rule. So a surviving spouse can still become the new owner of the IRA, can roll it over the IRA, can take it as an inherited IRA. They can elect the 5 or the 10-year rule, or if they don't make a selection or fail to do it, then they're going to be deemed the owner of that IRA. Some of these we've talked about, but it doesn't hurt to go over it again. So if the plan participant died before reaching the required beginning date, which is generally April 1st, and the spouse who inherited the IRA would not be required to pull anything out of the IRA until the year in which the deceased plan participant would have reached the age of 72. So that would be like a rollover into the surviving spouse's IRA, and it would allow the surviving spouse to then designate new beneficiaries on it. If a minor child hasn't reached the age of majority, while a minor, they receive the stretch, and then it resets to a 10-year rule at the age of majority. Doesn't count grandchildren in this as a minor child. And this does have an impact on trusts. So like we talked about, if you have a trust as the designated beneficiary on IRAs, you want to make sure you're thinking through the tax implications of that, and you want to make sure that your attorney and your accountant are weighing in on that. The age of majority we know is 21, so after the child's 21st birthday, they're considered age of majority. Disabled beneficiaries, so again, they can take it over their life expectancy. It requires a certification of the disability by a medical professional. And we're going to see an impact on trust, because if you have a special needs or a supplemental needs trust and the beneficiary or beneficiaries are all considered disabled according to the definition, then that trust would receive the stretch out. So we saw that clarification in February with the proposed regulations. Now, again, they're only proposed, they aren't finalized, but we did see that clarification. So what is a disabled beneficiary? So if you're age 18 or older, it's someone who is unable to engage in any substantial gainful activity. So note that it's unable to engage in any substantial gainful activity. So we do have some clients who are on SSDI, for example, or SSI and still have a job. So this would be any substantial gainful activity. So, and that would be by reason of any medically determinable physical or mental impairment. If you're younger than age 18, has a medically determinable physical or mental impairment that results in marked and severe functional limitations. So again, this must include the certification from a licensed healthcare practitioner. A chronically ill beneficiary was defined in the 2022 proposed regulations. So certified by a licensed healthcare practitioner that this individual is unable to perform without substantial assistance at least 2 activities of daily living. So it lines up with what we determine as skilled care, because skilled means that you need assistance with 2 out of 5 daily activities of living. So know that if you meet that definition, then you would be considered a chronically ill beneficiary under the Secure Act. Less than 10 years younger does not depend on identity or physical condition of the beneficiary. So it could be a sibling, friend, cousin, an unmarried partner. And this is the least complicated of those eligible designated beneficiaries. That category, this is the least complicated subpart of that. So can you use a trust for eligible designated beneficiaries? You can still use a trust. So as long as it's a trust solely for that beneficiary and that beneficiary meets the definition of eligible designated beneficiaries, or if all of the beneficiaries fall into that criteria. So I could see if you had multiple individuals with special needs, you could have one trust and you still get the stretch out there. So you want to make sure that all of the beneficiaries meet the criteria or meet one of the criteria of being an eligible designated beneficiary. So again, it could be a chronically ill and a disabled individual are beneficiaries of the same trust. They both meet the eligible designated beneficiary definition, so they would be able to get the stretch there. So it still has to be a see-through trust, meaning that none of the beneficiaries can be the creditors, charity. So again, they do have to be individuals. And termination of trust for minors prior to expiration of age of majority plus the 10-year rule. So again, this is where we're talking about those trusts that pay out at certain ages. So it's something when you're talking with your attorney where you might want to adjust those ages, because we now know what they think they're going to use as the age of majority, which is age 21. Okay, so let's talk a little bit more about some definitions. So we have some different types of beneficiaries. So we have a type 1, a type 2, and a type 3. And this is for where there's multi-beneficiary trusts. So a type 1 is a beneficiary trust, is a trust which provides that the amounts in the trust are to be divided immediately upon the death of the plan participant into separate trusts for each beneficiary. So that's the typical trust setup we think of. A type 2 multi-beneficiary trust is one that identifies one or more individuals who are disabled or chronically ill and entitled to benefits during his or her lifetime, and provides that no individual who is not disabled, chronically ill, or meets those other definitions would be beneficiaries under the trust. So that would be a type 2 multi-beneficiary trust. So when you're trying to work with a trust and you're trying to figure out how to determine the payouts, you have to ask, is it a valid see-through trust? So again, are all the beneficiaries individuals, no charities, no estates, nothing like that? Then you have to ask, is it a conduit or accumulation trust? Meaning that Is it just taking the required minimum distribution and distributing it right out to the beneficiary, or is it collecting it from the retirement account and putting it in the trust? And then you have to identify the tier of each beneficiary, because tier 3 is disregarded for all trusts. So you only need to know tier 1 and tier 2 beneficiaries, and tier 2 are the only matter if it's an accumulation trust. Then I wanted to remind everybody that part 2, and I feel like I wish I had some music that would cue up here, talking about how exciting this is going to be. On May 19th from 12 to 1, we're going to do our part 2 of this. Know that part 2, we're going to focus a lot on the proposed regulations as well as what we're seeing in the House and Senate from those two co-sponsors that did the Secure Act. So there are some changes that we're seeing, one of which I can kind of give you a little bit of a sneak peek of it. One of the things that they want to do is change the required beginning date for a plan participant from age 72 to 75. So that's one of the proposed changes. But just like anything, there's all kinds of other good stuff in there too. And we're going to go over that in part 2 on May 19th. So make sure to mark your calendar there. Like I said, we always put these up on YouTube after. So if you miss it, if you can't be here on May 19th, just check out our YouTube channel after. You can register for the seminar by either emailing Amy, calling our office, or you can get on our website. If you jump on there, you can register that way as well. So let me stop sharing my screen here for a second. Phew. So I felt like that was a lot of information. So I thank you all for being on the call. Like I said, we're going to have the part 2. Some of part 2 will go over some of this again, and then just talk about what we're seeing, what changes we're seeing. So it's going to be exciting. It's going to be a good time. So with that being said, I'm going to stop recording and I'd be happy to take questions. This is Samantha from the law offices of Samantha Wolfe, and thank you so much for joining us for our monthly virtual seminar.